Major breaking news, a huge oral argument, and it looks like it's going to be a winner there in the city of Chicago, believe it or not. Vandermeide versus Cook County, a huge fight over whether or not the Cook County tax targeting gun sales is constitutional under the Second Amendment. Stay tuned. We're going to bring you some discussions about what happened and some actual recordings of the argument itself. You're not going to want to miss this. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarm, What the Ukraine War Teaches Americans About the Right to Bear Arms. Check it out if you don't already own a copy. All right, we covered this several days ago. Major argument in the case out there in Chicago, Illinois, against Cook County, which is the county where Chicago resides. Todd Vandermeide versus Cook County. Big argument this week, and it looks very favorable if you're trying to read the tea leaves of the argument that we may win this case. Believe it or not, in Chicago. This is a lawsuit that started in 2022. It's been going on. The trial court out there in Cook County dismissed the Second Amendment and related claims, arguing that the argument, of course, was that these are unconstitutional targeted attacks on a constitutional right, and that money should be reimbursed for the sales taxes that were paid by people associated with paying this tax, targeting the Second Amendment, a fundamental constitutional right. There was a big argument this week, and it looks very favorable. Also, I suspect when you listen to this argument, I think it's going to sound familiar with some of the themes that I've been building up here, trying to educate the Second Amendment community, including the Second Amendment YouTube community, about how to think about the Second Amendment, how to deal with these various gun control laws that are clearly unconstitutional, how to argue this from a super legal geeky point of view. So why don't you check out some of the arguments that I'm going to play for you in 1 second. Tell me if it sounds familiar. To begin with, I should say that the lawyers for the plaintiff, Todd Vandermeide, the lawyer did a great job arguing it. You'll hear her argument, and you'll see that the judges, the panel of judges, really had concern for the lawyer for Cook County as to whether or not the lower court made a mistake. It seemed to suggest they were pretty sure that the lower court relied on legal precedent that had been abrogated, which meant wiped out already, and they should not have relied on that precedent, specifically a Illinois case called Guns Save Life 1, which basically applied the Second Amendment in a way that's inconsistent with Heller and Bruin and has since been abrogated. So to begin with, let's turn to the lawyer on behalf of the Second Amendment and her argument as to why this Cook County law violates the Second Amendment. Check it out.
May it please the court, Kate Hardiman for plaintiffs' appellants. At its core, this case is not about firearms. Rather, this case is about whether governments can single out and discriminate against certain constitutional rights for special taxation. When faced with that question, the United States Supreme Court and the Illinois Supreme Court have repeatedly held that the answer is no. To take just a few examples, the Supreme Court struck down a $1.50 poll tax in Harper and a 4% tax on paper and ink used by a newspaper in Minneapolis, Star Tribune. The Illinois Supreme Court similarly struck down a $10 tax on marriage licenses in Boynton. The teaching of all of these precedents is that no constitutional right can be singled out for special taxation. This principle must apply equally to the Second Amendment, and it renders Cook County's firearm and ammunition taxes invalid.
Very powerful language, pointing out obvious cases that say that you cannot target constitutional rights under either the Illinois state constitution or the federal constitution. Basic black letter law, that should not be a heavy lift. I've educated you all on this, and you've heard it right there. Sounds like they're making the same arguments that you all make, because you too are the smartest people in the room, and you too out there could have argued this as well, because we're training you to be, we're trying to force multiply and train you so you can make these arguments as well. The next major argument the lawyer for the Second Amendment made, a very powerful one, is pointing out exactly right that the lower court made such a terrible mistake by relying on a case that was no longer good law. Terrible. We see a lot of anti-gun judges across America try to rely on laws that have been abrogated or wiped out, if you will, by the U.S. Supreme Court in their precedents, and in this case, even by the Illinois Supreme Court. Check out this argument right here, right now.
Plaintiffs prevail for a simple reason on appeal. The basis for the lower court's opinion is no longer good law. This court's decision in Gun Save Life 1 has been abrogated in relevant part twice over, first by the Illinois Supreme Court in Gun Save Life 2 and by the U.S. Supreme Court in Bruin.
Good stuff right there, and I think that may be the winner. You'll see why in 1 second. But before we get to that, let's also turn to what we've been talking about before, the text. The text of the Second Amendment, the operative text, is the right of the people to keep and bear arms shall not be infringed. Now, the Supreme Court in Heller defined virtually every word, phrase in the Second Amendment, except they really did not get into one in detail, and that is what it means to infringe. That's right, to infringe, because the text of the Second Amendment is the right of the people to keep and bear arms shall not be infringed. But that's okay, because as we've talked about before, the way to handle that is you look at the same dictionaries that were compiled in the 18th century that the Supreme Court in Heller used to interpret the other words of the Second Amendment. How do they define the word, people, the right, arms, keep, bear? So whether you look at Samuel Johnson or you look at Noah Webster's dictionaries, they're all basically mean the same. If you look at the definition of to infringe, a verb, it means to either hinder or to destroy. And you'll see how the attorney on behalf of the Second Amendment does a great job discussing the definition of infringement or to infringe in the context of this fight over taxes. Here it is. Roll tape.
And here, Your Honor, most of the debate between the parties is about the meaning of the word infringe. And we have cited to you two founding era dictionaries, as well as decisions from two federal appellate court of appeals that hold that infringe means not, as the county argues, to destroy, but rather to hinder. So any tax hinders the exercise of here Second Amendment rights because it makes that right more expensive to exercise.
Again, to infringe means not just to destroy, but also to hinder. If you put a tax on the right to keep and bear arms, you make it more expensive, and thus you're hindering it. It's a total no-go under constitutional law. Can't do it. Now, let's turn to the next interesting point. Now, this is a part of the argument where the judges are actually asking questions of Cook County's lawyer, and you'll see how the judges are pretty tough on the government's lawyer here on the grounds that it seems to me, at least it seems from what the judges were saying, that there's no way, no how that the lower court ruling can possibly stand. And the lower court ruling was anti-Second Amendment. It ruled against the Second Amendment, if you will, and it seems like this panel of judges may be coming out the other way. You tell me what you think when I play the tape right now.
Yes, the judge in this case relied on a sole ground, and oftentimes when that occurs and that ground is wrong, and the parties haven't had the ability to argue why your other reasons for dismissal are incorrect, that they haven't even really had a hearing in the trial court. Would you agree? I mean, I know of cases where we've done that, but my question to you was the fact that she relied on a case that perhaps many would say is no longer law was her sole basis for dismissing the complaint, wasn't it?
Well, so Judge, I'll note that there was oral argument on the motion to dismiss where all of these arguments were raised.
Yeah. Well, I guess my question isn't clear enough. The judge didn't decide this case on any other ground except that she was bound to follow first district precedent. Is that correct or not?
Judge, I would say that's correct, but the judge also explained that the analysis that the first district did applied with equal force in this case. But
that's because she held that that case is still good law.
That is true, yes.
Okay, all right.
Now, this next point that comes up is very interesting because it arises from the Heller decision. As you know, in Heller, the holding of the Heller case by the Supreme Court was that handguns could not be banned by the District of Columbia. That's the holding. But in the context of the Heller case, there was what's known as dicta, which is generalized language that just talks generally about the Second Amendment. It wasn't necessary for the holding, but it is in the case. Cook County tried to rely on dicta from the Heller case that generally said that nothing about the Heller decision is supposed to adversely affect or impact commercial regulations involving the purchase and sale of firearms or something along those lines. So that was a big question and a big argument by Cook County, and the lawyer for the Second Amendment, the plaintiff for Todd Vandermeide, basically had this to say about that argument by Cook County that the Heller dicta makes a big difference in this case. Tell me what you think about it right here and right now.
This is not a qualification on the commercial sale of arms under Heller, and that is so for two reasons. This does not fall into the language about a sale because it's levied on the purchaser, not on, say, the firearms dealer. We think that language from Heller is meant to regulate firearm dealers who need to get a license in order to sell arms. It wouldn't fall or encompass purchasers as we have here. Second, Heller required that any of those qualifications or conditions must be, quote, long-standing. And under Bruin, whether or not something is long-standing is an argument about whether it is deeply rooted in history and tradition. Therefore, that language from Heller actually supports plaintiff's position that the county needs to ground its tax in history. And it has not done that below. It has not even attempted to brief history to this court. So that language from Heller is just not applicable here.
The last thing I want to play for you is a discussion about whether or not this tax on ammunition and guns is a targeted tax or a general sales tax. And this is an important distinction because if it's just a general sales tax that applies to everything, for example, it's not targeted. But if you target, let's say, guns and ammunition or ink, like we saw in Minneapolis Star, or voting, like we saw in Harper versus Board of Elections, well, you get into constitutional trouble. So let's see how this discussion goes when it comes to whether or not this Cook County tax on guns is a generally applicable sales tax. Roll the tape.
The county, two final points, Your Honors. The county argues that this tax is akin to a sales tax. That is just plainly not true. Plaintiffs would not challenge a generally applicable sales tax. Here we have a tax that singles out a constitutional right for special taxation. And therefore, the precedents of Harper and Minneapolis Star Tribune are directly on point. The principle, even though they were in different constitutional contexts, is the same. Constitutional rights cannot be singled out for special taxation. If that is the case for First Amendment rights, it must be the case for Second Amendment rights. After all, the power to tax is the power to destroy, as Chief Justice Marshall once recognized. It opens Pandora's box for this court to allow government to single out a constitutional right it disfavors for special taxation. If this tax is okay, the right to counsel can be taxed. The right to any other constitutional right that this court favors could be taxed as well.
All right, folks, so there you have it. Big argument, Todd Vandermeide versus Cook County. We hope that Todd does a great job and wins this case. Let's see what happens. I will certainly be tracking this, and when the decision comes out, we will cover it. And again, hope you learned something, and I hope you saw that some of the arguments made during this oral argument are very helpful. I will say that one of the great arguments that was made by the lawyer for the Second Amendment that I had not emphasized on this channel, good reminder, was the famous statement by Chief Justice John Marshall, an early Supreme Court justice, obviously. Justice Marshall said that the power to tax is the power to destroy. A great line. I was familiar with it, and I haven't used it yet. So there you go. I learned something from arguments too, and was reminded, I should say, the power to tax is the power to destroy. So when we talk about taxes on firearms, always remember that quote from Chief Justice John Marshall, the power to tax is the power to destroy. We need to start using that more and more going forward. I'm glad this attorney did a great job and made this point to the court, and now I'm reminded to keep talking about this when we discuss taxes and guns and going forward. So there you have it. All right, folks, hope you learned a little bit something here today. Make sure you subscribe, and sometimes, again, some of you getting knocked off the list, so subscribe and resubscribe. Don't forget to follow me on X at 4 Boxes Diner, and we will see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.